Hi everyone, a very warm welcome on behalf of whole LeDroit India team. My name is Riya Chabra, founder of LeDroit India, and I welcome you all on this eye-opening webinar on men's rights in India. Everyone is equal in the eyes of law, yet while empowering one gender, we have somewhere overlooked justice for another. This session will dive into crucial topics like false allegation, divorce laws, and the legal remedies available to men. With this webinar, we aim to shed light on the rights of protection of men under law. The webinar will be conducted by Advocate Aditya Rana. He is profound legal practitioner in the Delhi High Court and Supreme Court of India and one of our most cherished lawyer in LeDroit. With that, without further ado, I will hand it over to Sir so that he can provide you with an enriching experience. Over to you, Sir.
Thank you. Thank you all. Uh, First of all, good evening to all of you.
Good evening, sir.
We have 40 odd people over here. Everyone is here.
Yeah.
So,
Hello,
I,
sir.
hi. My regards to everyone. Myself, Aditya Rana. I'm an advocate practicing in Delhi and other forums also, not specifically restricted to Delhi region. But since 2013, it has been a in this noble profession. So this is my summarized introduction. Now, today we are, met up on this platform. Rather, the event which has triggered this kind of discussion over here, and many other multi-level platforms are there. There, these kind of discussions have been nowadays being taken on. So that's very unfortunate that event, that a precious life has been lost, and that gave rise to such kind of discussions. Now this has come to the larger picture. So before we start, I just want everyone to just be a bit interactive, what we all think, because it's not the kind of a session or a lecture or anything. So it's all about presenting your own facts, what you think in terms of law, because see, we'll only deal with law. We are not dealing with what emotional aspect says, what psychological aspect says, and other things, because see, law is basically what it is basically for protection and prevention. That's the whole reason the law is being incorporated, isn't so? I'll give you a simple example. If there was no such law in terms of traffic violations, what would have happened? If there was no such law that if you jump a red light, there will be some offense which will be marked against you. A simple example to this: the society has to be governed by law, because law, the basic essence is to protect and prevent. That's all, for a better society. So I just want all of you's view, because see, I'll not comment anything in terms that this was correct, this was wrong, this has happened. No, we are not here to rectify, because for that there are genius minds who are into the legislation, who are incorporating, who are day to day analyzing the law and then bringing it to us. Correct. So we'll have to just do a retrospective thing, that what is required, how in this given situation, how in given this particular environment of law, we can better safeguard the lives. That's all. How we'll keep our session here and after concluded to this only. So my personal view is that I'll not make any comments on this is correct law, this is wrong law, because see, law is law. It has been crystallized, it has been analyzed after the scrutiny of each and every aspect. Then it has been presented to us. So first of all, I want all of you to just be a bit interactive in the session. What you want to share, everybody is free. Switch on your mics, share your views. We can have a better, healthy discussion in that way. Yes.
Hello, sir.
Hi.
I'm Subramaniam from Chennai.
Yes. Hi.
Uh, I've just completed my LLM honors.
Let's just quickly go to the suggestion part, because see, we have a very limited scope of number
Sure,
of time.
sure.
Yes.
So the solution is there must be an amendment of criminal law bill in 2019 that is as much as possible, and the amendment of the definition of rape that should be neutralized in the
See,
Gender
yes,
manner.
you want to say that there should be a gender neutral system wherein every gender is taken at par. Each and every aspect is to be considered. Correct. The burden of proof is not only on a single gender. That's what you want to say today.
Yes.
Okay, I'll tell you one thing. See, today we are having a precise discussion that's rights of a man. Correct. Now, other than the rights which every person has, fundamental rights and everything, but there's a specific thing now we are dealing in. We are lawyers, or some of you might join later or down the line. You might be joining. As a lawyer, what is our responsibility? Nobody is talking about the responsibility of a lawyer in such a case. When we are a lawyer in these kind of matrimonial disputes or discords, we should keep one thing in mind. See, I personally feel, this is my view. Everyone may not support it or give it a second thought, but this is my view, how I think and presume because of my limited scope of experience. Now, what has happened in these kind of cases is these laws were there only to give you a easy and hassle-free, right. What was that right? If a partner, if two individuals, they are not compatible, and now it is becoming difficult to survive. So, on a very, you can say, honorable mode, they should part away. Correct. So there was a system that was derived. This was defined. Now, what has happened is now one thing is very much which I feel lacking in today's scenario is everybody knows about the laws, everybody knows how to arm twist, but the one thing which is missing is legal counseling. How many of you agree with that? If the
I
parties are
agree.
properly if the parties are properly counseled, see, we at the end of our pleadings, what how do we sign? We sign as, we don't write advocate, we write counsel for petitioner, counsel for respondent. So what does counsel mean? Counsel itself means that if there is any kind of a dispute, any kind of a legal right remedy which is arising or which is in favor or against your client, you have to advise in the best possible manner to satisfy that person. That is why he is here with you. I'm not talking about this case only. Let just we'll not discuss it because see, it's a case where individual events and facts are to be considered. It will be another matter of trial. It will be considered, but it has triggered a discussion today. So we'll have to see what are the things which are to be needed. First and foremost, a client comes to us. The first instance when the client comes to us is that he's or she is facing a trouble in the matrimonial relationship. That's all. The first prima facie is this. Now see how gradually it works. Petitions are filed. Let's just assume husband wife they are not keeping good relationship. Wife files a petition. Now there are certain altercations and everything has happened. They are filing criminal cases also. But at the end of everything, in the initial phase, the only requirement by the aggrieved party is, okay, let's just part away peacefully. Isn't so? That he should be punished, or the final verdict is that I should be set free from this particular bad relationship. That's all what is required. And for my survival, things should be accommodated. This is the sum and substance of all these cases. Now, let's just talk about maintenance in this case. There are five different enactments which talk about maintenance. You can claim maintenance in CRPC earlier, 125, now 144. You can claim maintenance in your DV. You can claim maintenance in HMA. You can claim maintenance in HAMA, Hindu Adoption and Marriage Act. So maintenance for a single term, that's a maintenance. It has to be derived from a specific docket of that income of that person who has to grant it. So we have five different. So see how it multiplies. That is to be seen. But as a lawyer, I always, practice this, that whenever a client comes to me, because I know in the initial time, it's only that the client is aggrieved. But later on, what happens? Half knowledge is always injurious. कहते हैं ना? Isn't so? There's a saying that if you know less, it is more harmful rather than knowing nothing. That is the main issue where it arises. Client becomes the attorney becomes just a person who is presenting the case. This is when it originates. We don't remember one thing, that till the time we are serving as a counsel, this becomes our paramount duty to clarify the things to the best of the knowledge to the person, that this is law, this is its procedure, it will take time, and this is how it will work. So we are clarifying your doubts. This is how this has to be done. So legal counseling is what is required as on date. Because what happens in these kinds of cases is initially it starts with rights, then it becomes a ego battle. How many of you have been to the family courts or practicing in family courts?
I have.
So
I am also practicing in family.
what happens in those court hearings? For example, court has just given a simple judgment, or just a simple order has been observed. Let's just assume that a person files an application saying, I want my registration rights. Now court says, okay, for that we'll make a specific arrangement till the time trial is going on. Finally it will be decided, but for interim we are granting you this. Let's just say that for in a week, let's just say a day will be fixed in the court premises, then the child will be brought, and you can, in the court premises only, wherever the counselor and every person is there under the surveillance of court, you can meet him. What happens? Parties move outside and they start hurling abuses to each other. Because now what has happened over here? For them, it is always that I have hired somebody. Now it is always my win. Isn't so? You all must have tackled this.
Absolutely.
Now, when a person
Yes, yes.
when a person is left
Even
at
in the
that,
case of maintenances, it happens.
correct. For example, court orders interim maintenance of 10,000. The moment you move out of the court, for example, you are for
The
the
client is never
right.
satisfied.
The moment you will come outside the court, they'll say, "Oh, you said I'll get 60 interim. Court has ordered 10." Now, because of this gap, between the legal knowledge and the interpretation, client is just oscillating. Who has to satisfy this? Are we only to present the case and just file a petition and then go on? No, because in these kind of cases, that client
No.
is emotionally and psychologically connected to you. He looks upon and she looks upon the counsel. So rather than just going for a hearing, it is a 24/7 job. I have my clients, they speak on calls for a duration of, let's just say, at max, I must have spoken to them, say, 1 hour, 2 hour, because you have to put them to satisfaction that now see the law is this, it will take its time, need not to hurry, because their anxiety level is always high. And when this kind of imbalances happen, these unfortunate events take place. Now I'm not again saying that laws are correct or laws are, see, every law has its own age, correct? Isn't so? How many of you support this? Is there any law which has been established in 4 decades ago and still holding good?
No, sir.
It
No,
changes.
sir.
It changes with the scenario. Now, we may think that now it's the apt time to change it. But we have to further understand this, that there are certain things which as a lawyer also we need to equip ourselves. I'm not blaming the fraternity. I'm not saying any blame game, but I'm saying we as a lawyers are duty bound. We also should now here and after, because it's an alarming situation. Because now, if we are just thinking that it's only a case of matrimonial dispute, we should further look into this with a deeper sense. Human lives are involved. If this divorce or this particular thing happens, it will lead a impact for rest of the life over the parties. So it has to be dealt very carefully, correct? Everything cannot be fastened up on the courts. They are delivering their best. We too have to come up with these facts. Now, as Subramaniam correctly said, the issue, the thing wherein it hits is the criminality, the aspect of criminality which has been assigned to this. For example, if we know that in this case the best would be that I'll have to give some compensation, that anxiety will be much lesser than if I know that if this case is proven, of if this case is filed against me, I may go into the jail. I have a difference in this. If I know that for this I will go to jail, my anxiety will be much higher. Right or wrong, I'm not deciding on that. But if I know today that I am only going to just be put to some compensation, some penalty is being fastened up upon me, my anxiety will be on a lower pedestrian. Now the issue is with the criminality. Now, how many of you support that it should be this criminality should be waived off, or it should be in a lenient manner? It is wrong nowadays. Yes. How many of you filed their falls and everything and everything? What is your view on that? I'll come to my view, what I have gone through, I have known, and what I think. But I want to know about your view first. Yes, you can just switch on your mics. Everyone is free over here.
So the first and foremost thing is that we need to legitimize the prenups. I mean, the prenuptial agreement before marriage when you are entering into a married life, because that's
Okay.
where the thing starts developing the problems. Because according to Indian culture, it is the marriage between the families, but marriage is a first of all a contract
So,
between the two parties. And the
correct.
second thing is, uh, in the year 2021, a plea has been filed in the Supreme Court of India that it has been demanded to set up the National Commission for Men.
Okay.
So through this, we will make the initiation that wherever
Correct.
there is wrong,
Hmm.
the marital dispute would be aligned in a way that the alimony and the maintenance should be compensated in a manner that is fair enough.
See, we have to look into the broader picture. We cannot just say that with few instances. Now, if we just recognize only the marriage, nowadays society is being changed, isn't so? Live-in relationships are also there, equivalent to putting into the just they are equivalent at par to a registered marriage, isn't so? If we just categorize it only to the marriage, then the aggrieved person in those kind of relationship, what will happen to them? Why was Domestic Violence Act 2005 brought into nature?
So
Because, yes,
I mean, there's step by step.
let me complete. 498A we are talking about. Let me just be very clear. Now, what we are at this particular stage discussing is 498A, isn't so? Cruelty. 498A was specifically to a married woman, correct? But when the society norms changed, when the society changed in this way, that people started living without even marriage, but this act of violence was still prevalent over there also. So this required a new enactment. That is why Domestic Violence Act came into the nature. It didn't say married woman. It just went to the position. It said a woman. If you read those acts, 498 says a married woman subject to physical and mental harassment by husband or the family members of the husband side, isn't so? In-law side. But when scenario changed, so another law was brought into, but what is happening now is multiplicity of pleadings are filed basically only to put arm twisting techniques. That is what is happening. And in this scenario, there are multiple judgments. See, what you are saying was criminality. For that, there is a specific judgment which has been, authored by the Honorable Supreme Court. It was judgment of Payal Sharma versus State of Punjab, which said merely by complaint filing against the husband and some relatives of him, you should not bring them to the rigors of law. Because what happens? 498A is cognizable, non-compoundable, isn't so? Non-bailable. So they said for this particular thing. So law is not sitting idle. They have considered these facts. The only issue is legal awareness. People just know that, okay, 498A will be filed, the party will be bent down. But the party against whom a 498 has been filed, he does not know his rights, or he is not being made aware about those things. Merely by filing 498, Supreme Court has specifically said in this judgment, Payal Sharma versus State of Punjab, that, for example, there was this example of father-in-law. He was bedridden. A criminal complaint about 498 was also levied upon. He was made an accused over there, and it's non-bailable, cognizable. Police can take action specifically straight away. So that judgment clarified the moment such kind of complaint will be filed, the police officer who is dealing has to give a detailed report first, whether this offense is made out against them or not. Now understand, for example, a sister-in-law is there. She lives in a far away state. Complaint is being filed. But the thing is, we have to update, we have to give the legal counseling to these people, because now we know the laws better than them. That is why they approach us with this hope that now you will guide them properly. But what is happening is, divorce, okay, it will be done, and we'll bring them down. This is wrong. This should not be done. Show the real picture. What is your exact question, Mitali?
Sir, even in section 125, females are nowadays putting false complaints, false allegations, and they are actually putting men behind the bars just for no reason, or you can say to extract more money from them. I've come across few cases like that. So in that case,
Now,
how to defend?
okay. Now you talked about alimony, correct? Or maintenance. What is the precedent which is based on which this kind of maintenance or alimony is, fixed? What is the precedent under which you file your income affidavits? Rajneesh versus Neha?
Yeah, income affidavit, yeah, assets,
Updated,
liabilities, and everything. Yes.
correct? Updated. Whatever may be the,
Yeah,
argument
updated,
on the
latest
other
one.
side. If I have only 100 rupees in my pocket, monthly I have 100. Expenses can be only given from this 100. Nobody can compel you.
Yeah, I had one case which was from Gujarat. There, the female demanded the property from the ancestor, that is from the husband's father,
See,
since
law.
husband was a legal heir of that family.
I am saying law has dwelled in the best possible manner and there are precedents. But what happens is those precedents are never discussed. If a 125 has been filed, as you said, pleadings have been done just to extract money. Because see what happens to that extent, I second your thought, because what happens, what I personally have also seen sometimes, that if a husband he is not getting a job, there is an observation that you are not working by choice. So it has to be neutralized. If a wife is also, well educated and qualified, she should also be. It should not be like that. Now a proceeding has been filed, she will stop working, or she cannot look for another job. So these kind of issues are to be seen. There are plus and minus, but we cannot say that now whatever the laws prevailing today, they have gone obsolete. Because see, these things what now have arisen from this particular triggered matter, these have already been taken care. There are n number of precedents. Now the only thing is, the person who is fighting this, the person who is on the first front line, has to take some faith that yes, law is settled. The person who is defending me or presenting my case has, in the best manner, told about all those things, that this will happen and this will start, this will be like this, it will become ugly at that time. So knowing everything in advance, well equipped, well prepared, isn't so? I'll tell you from my personal experience. Husband wife, almost at the age of 60s, they filed a divorce petition. Now, this is generally, we don't see those kind of cases. A person at the age of 60s, at the you know pedestrian of
I
60,
have
and
that case going on in Bandra Court.
so what happened in that case was similar, pressing for properties, everything and all. They were kids. They were kids from this wedlock. They were mature, fine enough. So I brought those matters to the mediation, and I said the mediation will only start when the kids will join it. Kids came, and I specifically told them, now you are the persons for whom they are fighting as on date, because they don't require anything. Mother was saying, I want money for my daughter. Husband was saying, I want, because they had, parted the kids accordingly. Mother was having the daughter, husband was having the son. So I told them that now the daughter, now you and your brother are there. You have to look into the best of it. So in that way, you can counsel them. Otherwise, what would have been the other way around? If I was for the husband, I would have said, no, 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 we'll file some civil suits, we'll file some other things, we'll go with the appeals and everything. So you have to bring down something, because here, strict interpretation cannot work, because it's a human aspect which is associated with these kind of cases. Social transaction is this. This is not a financial or a economic or a political transaction. It's a social transaction. Families are involved, kids are involved, the individuals themselves are involved. So you have to look beyond that. It's not just reading between black and white. You have to get, yes, Subramaniam, you want to say something in this?
Uh,
Yes.
am I audible?
Yes, yes, please go ahead.
So the thing is, in the Atul Subhash case, the person who committed suicide by it's not a suicide, it's a abatement to suicide. Uh, my perception is the wife and his in-laws have mentally tortured him, even after giving all the alimony, maintenance, and business uh, funds for his
Correct.
brother-in-law.
So for
So
that, they have been arrested also now.
yes, now they have been arrested, and a charge sheet has not been filed completely. So, uh, don't you think that is the legal terrorism that has been
I'll,
happening by the Indian judiciary, and
I'll
even
that
the
would see
judges is also
that would be wrong. That
corrupt?
would be a wrong statement. I'll just hold it to you right now. See, first thing you told, that charge sheet was not filed. How many
Yes,
days, at least a statutory period for filing a charge sheet is given?
According to BNSS, it's 180 days.
Correct. So how many days have gone?
I think it's 30 days.
So at least we should at least, not be in a haste to do a media trial, because everything has to be brought to conclusion. No innocent should be punished, and no guilty should pass away or sideline. Secondly, legal terrorism. That's a very big, word which covers. See, as I said, we are not here to support or deny, but we are here to suggest things. As I suggested, that we can just do best in our way, that we are lawyers. We can bring best of the things to make them understand, the litigants who rely upon us. How will we make them come to the best of the knowledge? We can explain them what is law, what is the procedure, how it will work. Now, what happens the moment the case comes? How many of you support this thought? Arey, we'll get you divorce, okay? And other than that, we'll just do such and such, blah 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 blah. We project this into the minds of the others, that you have best of the thing. Now we'll do XYZ. Those other parties, they will be crushed. What does it do? It creates a false image, it creates a false illusion in their minds. And now they live up with this. For them, the whole life is one case.
So my point of view is, if the honorable judge is corrupt, who is asking for 5 lakh Indian rupees, and she will settle this down, then imagine what Indian judiciary would be.
See, demanding and assigning, they are two different things. You must have seen other cases also. Nowadays, social media is very active. There are online court proceedings, recorded court proceedings also, wherein court is thrashing that for what you are requiring this. You don't satisfy the court. So it is not that if you had demanded 5 lakh, you have to be granted 5 lakh. For that, there is a specific procedure also which has been established. It might have been bit obsolete, or it might be losing its impact. That can be changed. But saying that the thing that has been claimed, it is to be assigned, that is wrong. The other party can always claim on the higher side. It is their way of pushing down or bending the other side. But law is here. We can defend also that. For that, affidavits, income affidavits play a very vital role. Change of circumstances play a very vital role. As I was just discussing with you, that personal case of mine, what I have seen from that case, why I learned from that rather, maintenance was assigned to the wife and the daughter. Wife didn't disclose that the daughter has already been married, and still the maintenance was going on, and she was receiving it. The moment we, came to this knowledge, we filed an application for reconsideration, and along with we filed an application for a contempt, that they have not disclosed it to the court. So immediate action in these kind of cases is required. We can Client will always say that pleadings have been this, but we have to put them that okay, pleading is this. You still have a scope to argue it. You still have a scope. If this has gone beyond this, you can still put it in an appellate forum.
So you just put on a shoes of Atul Subhash. Imagine that person, how patient he must have
See,
been doing this
correct.
trauma, and what sort
I
of
have.
torture, and what sort of uh,
That is why I said this
terrifying
is the
nightmares you
yes,
would have been
yes, yes.
faced while writing that suicide note.
That is why I said it's very unfortunate.
Law,
You know
law
that
and rules or just in paper, sir, and the procedures would have been followed when he was alive.
I'll tell you one thing. If that departed soul, that noble person, would have been counseled in a manner that, okay, this has happened, no issues. This is not the finality. Truth will come up. At least faith should have been developed. The only thing is that we can put words of, comfort to other side. Even if I lose a case, I tell to my client that, okay, if even if we have lost, it is that the law was not in our favor. That law says this, and we are having some lacunas in that. But at least I tell them that, okay, digest it this way. So see, only in this case, see, I may be very sounding very rude in this. I know this is one of the cases many other people like this must have correlated with it. That is very true. But we have to see one thing, that if we take a comprehensive look, if we take comprehensive look about the precedents, about the enactments, and the legislation which is functioning on these things, back of the you know way, when they are functioning, they all are taking all due steps for this. Now, you talked about Supreme Court. I was just following when I was watching this, and I also, it clicked into mind that now in one of the judgments, Supreme Court has said, oh, even if this is the scenario, we leave it to the legislation. When 498A was challenged, do you know that
Yeah.
498A was challenged? Sushil Kumar versus Union of India. So
Yes.
it said, we are not here to make laws. For that, we leave it to the legislation. Now, Supreme Court didn't stop over there. Now there is a recent judgment. There was another judgment that was Preeti Gupta versus State of Jharkhand, where they have made a suggestion to the legislation that now this should be curtailed in a way that arraying everyone as a party in this criminal proceeding. Because see, civil anxiety level is less. That what is there? Maintenance, money will be there. Okay, execution, no, nothing to worry. But when this kind of case is there, where you know fear about getting arrested, behind the bars, social taboo, and other things, court said we need to make a reference, because now what the word you actually said was legal terrorism, that needs to be ascertained. For that, Supreme Court said we have already observed in a case wherein we have specifically directed the police personnel who is dealing in such cases that first you take a report. Because I gave you the example, father-in-law was on the day, on the bed. He was a bedridden person. Even a complaint against him was filed that he has done some domestic violence.
So, for your information,
Yes.
uh, in court, while we argue, we don't argue on law. We argue on allegations, and
Okay.
then to support that, law is a weapon to procure the justice. Here, a man has lost his life. They
Correct.
forced him to
See, I'm
commit suicide, sir.
even I'm see now see
And you are talking about procedure that is knowledgeable, uh, but compared to human's life, even knowledgeable things comes secondary, sir.
okay. Now, what is your view on fair trial? In such cases, can a summary trial be done?
There must be an arbitrary of courts where there must be gender neutral laws, uh, where every single thing should be uh, maintained in a way that there must not be any sort of feminism or any sort of biasness in the legal rights, sir.
See, we come up from a society wherein we ourselves have developed this notion. Sorry to say for that. In our society, when iron was to be extracted, it utilized force. It utilized, muscle power. So from there it developed that it is only in the ambit of the males. So it developed from there itself. Now, just let me complete. You said arbitrary. Now, there is a procedure which has been laid down, keeping in view that every aspect is to be tackled in a very precise, not in a precise manner, in a thorough manner. So everything is touched. For example, if a maintenance is to be granted, now maintenance should not be granted, haphazardly that, okay, you are earning this much, 80% should be there. No, it has to be seen for the betterment of the other party and the person who is paying it. There are certain, this does not become final the moment it has been granted. For that, our system, legal system, has said that even if that happens, you can just go in the appeal, you can challenge that. Correct? Now, you said we are arguing on facts, sorry, we are arguing on allegations, but allegations supported with evidences, and then law comes into it. Now, for that, we can, again, we come to the square one, legal awareness. If a person knows that okay, there's let's just put one allegation and then we'll discuss it. For example, the allegation is that the husband was not maintaining the wife in the best manner. This is the allegation, correct? Husband has all those records where he has taken all the expenditures, he is maintaining the payments of child, wife, medical, everything. So it has to be proven from that. You cannot say that, okay, see, the thing which has happened, it is, very sad to say, but this has happened. But we cannot say just because this has happened, law should be like this, that, okay, do a summary trial and finish everything. Gender neutral, I supported. I said, yes, gender neutral should be there. It should not be that you have left, for example, a person is not in a fit financial conditions the moment these cases are filed. Even in this case which we are discussing now, 9 cases were filed, and that too far away from his place. He was working in Bangalore, and the cases were geographically at a distant place, isn't so? So 9 cases.
Jaunpur.
So those cases to be, uh, carried away, taken into the legal proceedings to be attended and everything. I was even watching that if a detailed analysis was there, that there was almost for past 3 years, he was there at 120 court dates. And being in a very private national, it becomes very difficult. For that, even though I'll not support this, but I'm just saying that we can put, as a lawyer, we can say if this kind of situation happens, as a lawyer, we can put our client to this suggestion that we can put a case, for example, in civil, we can represent you. There is no requirement of you coming up and down. We can handle it. Secondly, if it's a criminal thing and criminal trial, you are facing difficulty, we can do one thing. We can utilize the legal remedy of transferring. But that also depends on case to case. Because see, we cannot only say that now all the cases are false. You should also, accept this fact also, Subramaniam, that if we label all the cases as false, that would not be correct. I'm not, arguing on the side of one. I'm just saying that yes, gender neutral is to be there. For example, in a case, a person, he filed a divorce petition, and the moment he filed the divorce petition, prior to that, that person sold out all his properties to his father. His father passed a memorandum in the newspaper that I disown him from my properties and all. What is that? These are the suggestions we only give them, or these are the suggestions they take. Now, what will you say in those cases? So we have to look through a prism where we don't, put everything on a bracket and just multiply it with false. Yes, Harsh? You want to say something, Harsh?
Yes, sir.
Yes.
I understand your point of view, and I accept that there are many genuine cases which needs to be, uh, you know, taken into taken into a genuine perspective. So here there is some sort of statistics.
Correct.
I want
Now,
to
for
read it
that
to
we
you.
have, see, statics. When you talk about,
Huh?
there is you talked about statics, है ना? There's
Statistics.
some statistics. Now, NCRB, National Crime Record Bureau.
Yeah,
Why was
that's
this
what I'm
formed?
going to
है ना?
read about.
हाँ,
The total suicide in 2021 report
हाँ. So,
was 1,64,033,
correct.
and married men committed suicide was 81,063, and married women was 28,680.
Yes.
एक्सक्यूज मी सर, सर मैंने अपना क्वेश्चन गूगल मीट में मैसेज में ड्रॉप कर दिया, प्लीज उस पर थोड़ा बताएं.
About family distribution from great grandfather to their highest. See, that is altogether a civil nature of a litigation. So it's not remotely connected. I'll get back to you later on. Yes, Subramaniam.
So this is the statistics, sir. This is the number, and the it has been read in Calcutta High Court's judgment that uh, the misuse of marital laws in India is a legal terrorism. Even the
Correct.
Supreme Court itself has criticized this law,
Yes, they have
including
criticizing. That's why I said Preeti Gupta state of Jharkhand is what Supreme Court has observed. If I read that, the line that was over there, that was that a serious look into the entire process is to be required by the legislation. They said as on dates from this facts and from this numbers which you just narrated, it gives an alarming situation that now what is happening is earlier 498 was only for a dowry. Sorry, for saving the person from physical violence and mental harassment pertaining to dowry and other things. So now they said that now it is being taken as a weapon, legal weapon. So it has to be ascertained to some, because see, Supreme Court every time has said that whatever law has been set up by a legislation, we'll have to only put ourselves, we'll have to only ascertain, see these cases in the limit of that. Laws framework is a different altogether aspect. We have three different stages: judiciary, legislation, and execution. They have all three are different in their works. They are not dependent on each other. They are independently working. So for that, they have already said. Now, kindly see the beauty of the Indian law. I'm not saying that we have to praise it, but I'm saying, see, even this particular scenario, now the person, he has lost a life. Now, that is also not being left like this only, that, okay, in some pressure or something he has done. No. Abetment to suicide is already there in our penal laws. Had it not been there, was it any possibility, remote possibility of taking any action against these people? So we have to see that our law, which is codified, is the, you know, best expanded law which covers everything. You must, at least put your concern to this also, that nothing remains untouched. It's not that any aspect which is any injury, any legal harm which is there remains untouched or un you can say that is not curable by this particular thing. So for that we have to, just put one thing, that is legal counseling is, which is, as per my knowledge, which is required.
Sir, can you please give reflect to my question I have put in the chat box?
I'll just see as not ambit of counseling them. What's more can be supported on part of men case are lawyers in which they are dragged in front of unnecessary by wife and their family. Now, see, even if dragging into unnecessary cases is there, for example, a case under 498A has been filed. Understand it like this: altogether criminal in nature, correct? take it as in parallels with a purely criminal case. Now, to prove your allegation, what is required? In a criminal case, charge sheet will be there, 498A, report is filed by the officer which is assigned. Now, does everything rely on the report? No. Defense evidence is not there, but cross-examination is always allowed. Prosecution can put the evidences, but you can always cross-examine the prosecution also, prosecution evidences. But now we say that, okay, these false cases, even though there are false cases, who has stopped you from filing counter cases? Who has stopped you from filing quashing? Law is there. For example, I know the allegations are false. Why should I wait for trial? I can also file another case against this false complaint, false allegation. Yes, Subramaniam. Has there any embargo to this? Is there any estoppel to this? I don't know about the exact section, but earlier 211 IPC talked about that for a false charge with intent to cause harm.
Ah, that was only for the police investigation, but not for.
But I am saying, see, this is also based on some findings of the authority. It cannot be merely decided on the allegation of the party.
No.
182, giving false information to a public servant.
Yes.
If you can prove that wife has given a false information, public servant has acted on that information.
Yes.
If you
That's
feel
there.
defamed, you can go into defamation also, that these grounds were not maintainable, still defamation is there. So, see, we have to, gender neutral is one thing that is the most sensitive topic today. That gender neutral laws need to be, applied, or these laws need to be refurbished. They need to be upgraded. Because what has happened by the passage of the past utility of these laws, people have started looking into the loopholes. Correct? Second thing, again, once they are upgraded, legal clinics should be there. Third, authorities. Now, kindly see how many authorities are involved in such kind of cases. I was very astonished to see when I was reading all this. So I saw in a simple case which looks like a matrimonial discord, private detectives. I was surprised. Even outside our chambers in our district courts, there are advertisements, private detectives. Then mental health is a new issue. So therapists are also there. Their reports are also put. Correct. Then counselors, then police, then of course the lawyers, and then media. So see how many people are to be, uh, actively working in these cases. So now also to put an enactment to how they will work, how they have to be codified. Otherwise, what will happen? Uncurtailed power is also harmful. If a police officer is given all the charge that whatever you will be observing, that will be the truth, that is also wrong. If he is restricted to certain things, he cannot go beyond that and investigate. That is also wrong. So we have to put, now rather not we, the legislation needs to think that it is the time, at time. Now it has been an alarm. You need to revisit it. For example, people have been doing. See, as I gave you the example, the husband, the moment they have filed a divorce case, before that 6 months, they leave their jobs. Wife who was already working, the moment the divorce case is filed, she goes and sits with the parental place and quits the job. Now I am not getting any job, not even going for that. So that is to be seen that this is how it has been working now.
Exactly. So I come to my own experience, sir, that uh, 9 years back, I made a odd film on how false cases have been um, prepared during the years from 2014 to 2018, and I um, put on the statistics in my
Just
short film.
pardon me. There's some query from Urvashi Manwani. Is she still in the session? Are you there, ma'am? Urvashi Manwani. Okay, tell you no issues. Are you there, ma'am? Sorry, she is there. Can you just switch on
Yes,
your
sir.
mic? Let's just have a
I'm
word with you.
here.
Urvashi, you there? Let's just have a word with you. You said that session was only for advocates. No, I'm just saying, as a litigant, litigant, what is litigant doing with an advocate? Litigant has instructed that this is my case. So now litigant also should be well aware that is that case being followed upon properly or not. The only word which has a lawyer been suggesting me, is it correct or not? You cannot just blindfold yourself and say, okay, whatever the lawyer says. Can it happen? Everybody nowadays is at least, well read enough. You may not know the procedures, but at least the basic, that yet this is correct, this is justice, this is justifiable, this is not justice, this is wrong. That common interpretation is with every individual. The moment you, as a litigant, also sense this, you should take your right, because now you have assigned this case to a lawyer, and you are paying for that services. You cannot just sit back and relax that, okay, whatever service is getting, it's okay. For that, these basics, if your evidence is not led in a way, for example, you gave a very relevant evidence to your lawyer, you said that this is the relevant part of the evidence, you put it before the honorable court, he is not doing it. Who has stopped you as a litigant? Most of the time I have seen in family courts, the judges sitting in family courts as a principal judge over there, they directly communicate with the party, because they also know the fact told by the client, the fact narrated by the counsel, there must be another fact which is the reality. So they directly interact. They take in this chamber hearings also, that they bring both the parties without the lawyers. They say, okay, just sit, and they try to analyze that what exactly the situation is. So keeping mum in the court, just because I have hired a lawyer, I am just relaxing in the backseat. Let him argue. If he, even if he is not arguing in the direction what I have said, then who can be the best person to affix this particular reason thing, that you are wrong on your own part, that you never raise your voice. So this session altogether is not for advocates or some litigants only. I'm just saying that a common notion is there. Now, this thing today, it has alarmed, it has triggered this issue, but it was prevailing since long. Acts have been amended in that way. Judgments have been passed in that. Procedures have been formed in that way. Earlier, in time, in terms of interim maintenance, only the salary slips and everything was seen. That's all. But the moment the Rajneesh versus Neha judgment came, the particular format, the performer of that affidavit was drafted. That no, you have to put it in this way, so that everything comes into the picture. So uh, judiciary is also trying to, if there is any lacuna, or if there is any day-to-day proceedings are going on, if there is something new which is coming into their way by virtue of these hearings, they're trying to figure out that how this can be weeded out. Yes, Subramaniam.
Sir,
Yes.
this so I made a odd film on how the false cases have been reported, and according to NCRB, there were 70% of all cases that has been uh, quashed by the court. So the problem here is understanding the uh, education is something, because those people who has been graduated are all half educated people. So those who have studied or obtained degree here has studied only for thousands of pages of books and responding to the topic of the feminism or the legal cases and all. So the problem caused by is that the graduate are all half educated. This is the major problem that is to be corrected, and the colleges are not educating law. They educate science, they educate commerce, and for to be in this civilized society, they need to be upgrading the course of law for every student, and it is the fundamental right. So, so the solution here is, uh, if you we could make the Indian legislation to be more tidy and more, uh, you know, uh, constitutive in a manner where everyone should be the same.
Mm-hmm.
The first of all, the false allegations of matrimonial dispute or rape or sexual harassment or molestation, uh, whatever it is, to make people more aware in the society, it is very important to educate them how to take the legal steps against these allegation made by women through different campaigns.
See, now we have started talking about gender neutrals, but we never, you know, supported this, that already these aspects were coming in way. Why was Amesh Kumar case filed for just because that this domestic violence case or harassment case was filed, cruelty case was registered, all the family members were roped in. That's why this case was filed. So the origin of what we are discussing today, it was then also, but it was being dealt. Now legislation needs, what I think from my point of view is, legislation needs to think that certain notions, that if a case comes, prima facie, it's a case where the person is aggrieved. That should be removed first. That, for example, if a lady, if a female has filed a case of cruelty and everything, first burden of proof should be levied. That you just prove it. Otherwise, what is happening? Just filing a case, it puts whole of the family into harassment, and that is what people actually fear about, isn't so?
Yeah, that's exactly what I'm saying, sir. We have to educate these
The concept of
people.
the concept, why was the concept of marital rape taken so seriously in the honorable high court and supreme court? This was the issue, that what will happen if this kind of allegation is levied in this case also. 377, who will prove it? So if we do not put some bar, or if we not restrict it, it will definitely turn as a uncontrolled monster. So that has to be looked into now by the legislature, that all those tactics which have now been relevant from the passage of time, they need to be curbed first. This notion, basic notion, that yes, aggrieved is there, and the basic notion that yes, whatever complaint has been there, this is a correct complaint, a burden of proof is not levied, that needs to be established on the threshold. Otherwise, what will happen? It will become a money making or a pressure building tactics. Yes, Anmol? You want to say something, Anmol? You raise your hand. Okay. Anyone wants to share any other thought over this?
Sir,
Yes.
I do agree with you with the legal counseling, the procedures and all the words that you have spoken. It's theoretically great, but on the ground, practically, from where
See, huh?
we can get all these
there needs to
evidences
be
from?
there needs to be some kind of uh, authority, some kind of, say, some department, at least, wherein, for example, a complaint has been filed, a person against whom this is filed, he can take that grievance, that okay, now what are my legitimate rights, at least I can uh, ask them. So that needs to be formulated. For example, there are CAW cells, correct? Now, something of that view, that if something of this nature is happening, where will a male person go? That needs to be established. For
Exactly,
example,
sir.
uh,
So my
police,
point of view is, uh, likewise, there is a Mahila court in India.
correct.
There should also be a men's
Not also
court.
be, it should be, let's just say, rather than my if I say in a very raw sense, I will say that there should be a division bench kind of a thing.
Sir, hello.
Yes,
Sir, am I audible now?
yes, Anmol.
Sir, Shubhra Badliam has right now said that graduated are half educated
No, he
and
said, no. He said something different. He said only the person who has graduated, read thousands of books, he can go into all those things. And now, if a person has only graduated in some other stream, he's not a law knowing person. He's not a person who has, done any degree or anything specifically specialized in law. Then what will happen? So for that, we were discussing that there should be some, at least some clinics, some organization should be there who must be making male laws also aware to the people, not only on if you can see, there are hoardings, if ये सताए हमें बताए, sort of. So this is not the way it will work. It has to be put to some legal, some procedural correctness, that now authority should be there. Like police has to be specifically trained in dealing with these kind of cases. There should be a specific procedure protocol. That simplicity,
Exactly,
simplicity
exactly,
of
sir.
making a report, filing an FIR.
Yes,
A CAW complaint has been made. Two counseling sessions, 1 and 2. It goes, wrong. You just refer the matter to the FIR. No,
sir,
understand?
what my suggestion is, sir, you are absolutely right, sir. Sir, I also used to think that there must be some authority who used to screen out these false cases.
Okay, I'll tell you one thing. Basic example. If police person does not register your FIR, what do? You go to the magistrate. You go to the magistrate.
Yes, sir, yes, sir.
A Miller approach can be taken. CAW complaint has been filed. This mediation counseling sessions did not work out well. Observation of the CAW in charge is there, that okay, they are fit case, they are not settling. Fit case, my observation is that yes, this offense has taken place. But straight away registering an FIR, it opens another grade. Now the person has to tackle it from taking bail, taking anticipatory bails, taking regular bails, doing all those trials, making preparations for the defense of criminal case. So it can be done. Okay, if this is there, if FIR is not registered yet, you can go to the concerned magistrate, place your case, face the trial, burden of proof is there, prove your case, then get a FIR registered. By that case, a proper hearing will be given to the other side also. And people will not get this notion that okay, just simple writing 2 lines in a page, putting it to the CAW, everything is done. No, For that, procedures need to be developed. For that, training sessions need to be given. More and more persons who are dealing with psychoanalysis, dealing with other things, medical specializations, they need to be roped in. Merely by saying that, okay, unnatural, this has success been done, how will you prove it? It has to be through some proper investigation. It has, otherwise, what will happen? Anybody can claim it. So for that, legislation needs to now timely check all these aspects that are, falling apart. The
Right,
intention
sir.
of these laws was always protect and prevent, but now those intentions behind these enactments, they are to be at least, what you can say, serviced, so that they don't go obsolete. From IPC to BNSS, from other things, this is how it works. Now, these laws also need some brushing up.
Excuse me, sir.
Yes.
Sir, now you have told about the police must equip themselves in a manner of looking what is uh, genuine cases and what is false cases.
Yes.
There is a example that in Saudi Arabia there is a, a department called Amity for Prevention of Virtue and Prevention of Vice, where the government of the authority that enforces the moral value of the country.
See, the laws over there, they are more stricter than ours. Do we follow
Exactly.
them? So,
That that has to
and
be
moreover,
um,
our society does not, allow, verbatim or parameteria implication of those laws. That will be a very difficult task in our nation.
yes, sir. It will be
Hi,
difficult.
sir. Sorry to interrupt, but the session was for 1 hour till 5:30, and we have already expanded it for half an hour.
No issues, no issues.
Yeah.
We'll just sit some time when it's kind of, see, these kind of debates, they always are in a, positive manner, that at least from our end, we can just do this to, eradicate these kind of things. Because now when we are sitting in a society, we cannot just sit close eyes and say that whatever has happened in different house, so why to worry? If a fire is caught in a house, it will affect the other one day, or tomorrow it will definitely burn others also. So why to wait for that day? God forbid. So appropriate prevention is better than cure. Thank you
Yes,
all. It was a
right.
very enlightening session for me also. Thanks a lot for being so patiently listening to this. Thank you all.
Thank you, sir.
Thank you.
Thank you so thank you everyone so much for attending the session. I hope the session was very much enriching for you all. Please give a thumbs up for the sir and the clapping through your this emojis and all. Let's appreciate him for sharing his knowledge. Thank you very much. So for those who have joined the workshop group, we will be sharing a feedback form over there. You can fill that up in order to receive your workshop certificate. uh, Stay connected with LeDroit India for more such enriching experience. Have a good day ahead. Thank you.
Thank you.
Thank you
Thank
to
you.
the team.
Thank you so much.